possibly, surveillances and monitoring over our telephonic communication. It's not constitutional. It should be held to be unconstitutional. This should be stopped somewhere. But for public safety and emergency, constitutionally we are ready to done away with certain fundamental rights. No single fundamental right is absolute, that we can run it through mechanism or through comparison of Article 19. No single freedom is absolute. There are reasonable restrictions. But the question is that whether it needs to be judged on a very context that whether those restrictions are reasonable or not. That's the very basic thing what we need to follow. Because if those restrictions are not reasonable, then we have a trouble. Then we may have a situation where we cannot think of, encompassing that area which we say, okay, constitutional ethos versus privacy. We cannot. The whole point is, in this particular case, when the issue came in, they again emphasized onto it that we are not denying surveillance. We respect privacy, but we do not undo surveillance. Now here the question was as to that reasonability as a factor. They came in with certain guidelines. I mean, in those days, 1997, the issue was not like only about surveillance being done, not done, but it was also about how it is being conducted. Tomorrow, if a police or a cop who is maybe at the lowest rank of police investigating into it, maybe somebody like at the office of inspector of police or somebody, possibly there would be a different challenge. Reading constitution, understanding the logic behind constitution at one end. But subsequently, when you say somebody is challenging the very ethos of the constitution just by mere one act, surveillance on phone, and that too it's just suspicion. It can't be proved that whether it is emergency, not an emergency and all of that, because it would depend upon what communication person had. So obviously they were stuck with one issue, that do we have guidelines or do we have a proper mechanism, a reasonable procedure for getting into privacy of the person, surveillance. So they gave the guidelines. Now what are those guidelines? In total there are almost around 8 to 10 guidelines, to be very precise. I believe there are 8 guidelines which are given in that judgment, that how it can be adhered to, how you can actually conduct the surveillance. No doubt they gave more importance, they upheld the constitutionality of that section 5, but they also said that it has to be reasonable. That now how that reasonable factor has to be construed, how it can be done. The courts came up with, the Supreme Court came up with that logic, that how that reasonability can be maintained. It can be maintained by virtue of having a competent authority appointed by appropriate government. So you need a competent authority who shall look into the whole matter. But obviously when you see governmental structure, obviously any government, central, state, would want it that if surveillance is taken, everything under the sun against a person, if they want to use it for whatever reasons you may call it, maybe a political reason or maybe a political vendetta which is involved most of the times when surveillance takes place, they might take it as a matter of fact that no, we have surveyed it, we have kept a surveillance and we know for sure the communication is related to public emergency. They would try and prove that. And that's the reason the court came up with one more logic. Till the time you come up with a competent authority, we think that Union Home Secretary, Home Ministry Department, Secretary of that particular department must be appointed, and he should be part and parcel of that commission which will look after all these changes. Now how that commission was established? They said minimum 3 ministers from a government, they must be part and parcel of that commission, and Secretary of Home shall be the competent authority to whom such issues related to privacy could be mentioned to. We'll keep the surveillance if we require, and if you have an issue regarding that, you complain it to them. Secretary of Home. That's how the whole structure came in. Now the issue is, it was not just about allowing surveillance, but there was something else. Post this particular judgment, which is respected and which is most usually followed, that yes, we have a practice of having a commission and making some rules regarding how a surveillance can be kept in case of public emergency. I mean, a good move. When you don't have anything, people blatantly use powers at their own disposal. Any policeman initially would go and say that, see, we have the power, we will survey. In olden days, the situation was little different. Now, when I say olden days, I must construe myself to that era where I say only we had service providers which were government undertakings. BSNL, MTNL. This is the very popular service providers to us. In those days, it was all fine. The issue is little different. In section 25 of the Telegraph Act, they have also stated something, that we'll have rules for surveillance and all of this. And I hope you are all aware, we have telegraph rules also in India. And there are two rules which come very much in conflict, especially in terms of rights of privacy, and which are discussed in the behest of privacy and telephonic surveillance. I hope you are all aware. There are few factors which do come in over here, especially in line with how the surveillance is kept. There are rules made post this particular case, PUCL. The challenge is that these few provisions are very much in line with that old era where we had only BSNL and MTNL. Because section 25 makes it an offense under Telegraph Act that any person, if he enters into the premises and tries to have an access to whatever materialities they have in telephone exchange, it's an offense. So what government was constantly doing, or rather what these public utilities were constantly doing, that they were claiming to be big daddies, saying that, see, BSNL, we have a very good procedure. What procedure we have? If a person enters who is not an employee of the telephone exchange, he can be booked under section 25 as an offense. So we keep a proper reasonable care of it. So you should not worry about your own privacy. We are not going to make it public. But see, it's not the question as to whether it is being made public or not. Somebody knowing that I am communicating this fact to somebody else, that itself is breach of privacy. Service provider acting like God, we don't trust them to be gods, right? We can't trust them to be gods. So the same factor came in again and again. Obviously, PUCL was the first ever landmark judgment which established this situation that, okay, fine, we will allow surveillance, but only in cases where public emergency is truly established with reasonable procedure. And what is that reasonable procedure? Rules. Rules will talk about it. And that's what that, very idea of incorporating Home Secretary as well as Home Minister, Union Home Minister into the set of commission was proved to be a successful modality up to a certain extent. But see, that doesn't stop the very essence of surveillance, litigations related to privacy. Few more judgments came in. I hope you are all aware, 1997 was this thing, PUCL. 2003, Amar Singh versus Union of India. Another judgment which is very much known because of the political vendetta or political rivalry which was enforced through the facts. Amar Singh, I hope you are all aware, UP's Samajwadi Party leader, the then Samajwadi Party leader, then he came out of Samajwadi Party. Again, now there is a realignment going on. And now I believe that he is still with the newly formed Samajwadi Janata Party. Yesterday we had a realignment of it. Now Janta Parivar. Well, in the past, in the year 2003, Amar Singh substantially had a political differences with some of the leaders in Samajwadi Party, and suddenly he made a public outbreak of a fact which the then state of UP didn't like or didn't say anything about. It was about surveillance over his mobile contacts. In 2003, Amar Singh announced it before media that I am scared because I believe my mobile phone is getting tapped. An inquiry was conducted, constitutional rights came into question, he went up till High Court, Supreme Court. It was a writ petition which he challenged, which he put forth, which he said to be violative of his fundamental rights. Some substantial clues, evidences were found in that, but again the same thing, public safety, public emergency, all of that came in question. The offshoot of that was that political vendetta was an issue, was somehow substantially seen during the judgment, during the case, post that case as well. But one must understand that it's not the only judgment which stated the overall view as to public emergency, but also forced another issue as to it. Surveillance, the state said this, that the surveillance was conducted as a matter of normal procedure. There was nothing political about it. You are a VIP, so obviously we need to survey it for your safety. So they gave altogether a different color to it, rather than banking on only to that public emergency as a factor. State never claimed this, that it is matter of public emergency, but they said it's a routine procedure. Out of few VIPs, we may have certain surveillance just for their own safety. We just want to see whether they are under some threats, whether they are under some, they are manhandled, or they are handled with different illegal kind of factors in the society. So we're just observing that. We are not actually breaching the privacy of the person. Now naturally, when we say that surveillance privacy is imbibed through this kind of procedure, all the time the question of public emergency may or may not come. You and me, when we are involved in any kind of telephonic communication, we may say, okay fine, somebody may observe my communication, we know service providers sometimes do it, but what kind of mechanisms we have for challenging such things? Technically, Telegraph Act, the fact is that the Telegraph Act is okay with telephone tapping or possibly with breaching of privacy of the person up to an extent of public emergency and public safety. So if a person is involved into any kind of illegal activity and there is an emergency, obviously they will say okay to it. It will not permanently validate the breach of privacy via breach or interception into communication, but if there is a reasonable mechanism followed with the help of section 5, it may stand as constitutional and valid. Always remember this. Now if it is done in the context of privacy, breach of privacy at a constitutional level, at a different level with public emergency or threat to national security and all of that, it's a different story. But in modern age or in current world, very often we come across those situations where the private communication is targeted by a private party. It's a different story altogether. Why? It's fine if state does that with a state mechanism. We are more scared when a private individual intervenes into the privacy for all his private reasons. That is more dangerous than state is getting involved. State, maybe because of all the factors which we discussed, right from Kharak Singh till this Amar Singh's case, all 4 or 5 judgments which I discussed today, possibly they just meant one thing to us. Constitutionally, we may say that yes, there is a procedure established by law which will allow under Telegraph Act surveillance by the state, right? But the issue is this surveillance is little complicated when it comes to the private party, because anyways against private parties you don't run to the courts for fundamental rights protection. Rather, they cannot be charged with that. Then what do we have in law to establish or protect our own privacy? Now this is where certain provisions of the other law which we have discussed at length, possibly in the last few sessions, information technology law, those few factors come in for our help. Firstly, as I mentioned it to you, Information Technology Act has all the definitions of it, including computers, computer systems, computer networks, as well as communication devices. We have already discussed that. Communication device is very much defined under section 2 subclause TA of the Information Technology Act. Now you will say, sir, what is this? I mean, in Telegraph Act we don't have that particular factor, but under information technology we have it. We have it because of that very reason that we want it to be as a part and parcel of wrongs which are criminal wrongs in force. Telegraph Act doesn't provide for those set of offences altogether. There are certain set of offences which are discussed under Telegraph Act. TRI Act doesn't mention anything in terms of criminal wrongs. We had no other choice. Why? Because TRI is meant to be a civil legislation. It is meant to be providing services. The very purpose of the TRI Act is reading services, providing services, regulating services. It is not to do anything with criminal wrongs. Now what is there in terms of privacy under Information Technology Act? Section 43A, small a, illegal access. It says that if any person without the consent of the owner or person in charge of a computer, computer system, computer network